criminal myth that is not true is that the prosecutor cannot use your statements against you that you make in a proffer. And now this is the biggest lie and this is the biggest sales pitch when your attorney or when the AUSA says, whatever you tell us is protected, and you get this thing called queen for a day and it sounds fabulous, and we're not going to use your statements against you. That is a big lie because there's 5 exceptions that allow the prosecutors to use your proffered statements against you. And if you don't believe me, look at the actual proffer agreement and go through what you're committing to. And 5 exceptions will most likely be there. Sometimes it's 4, but all these factors are in there. The first way they can use your statement against you is to prosecute you for making a false statement or perjury. If you lie in the proffer or if you omit a material fact, the prosecutors can use your proffered statements against you in a subsequent case for this other perjury prosecution. The second way that the prosecutors are able to use your statement against you is what's called derivative use. If you tell the prosecutor, I robbed a bank, the prosecutor cannot use your statement that you've robbed a bank, but they are able to go to the bank, investigate it, interview witnesses, get video surveillance, and so they can use your statements to derive other evidence. The third way prosecutors are able to use your statement against you from a proffer is if your attorney at trial takes a contrary position to what you've said in the proffer. Third way they're able to use your statements against you is if you take the stand in your own defense and if you testify contrary to some of the things that you've said. And if you testify contrary to what you said in the proffer, the prosecutor is able to introduce your proffer statements and cross-examine you about those statements. The other way they can use your proffer statements against you is to determine your safety valve eligibility. So if you go in and if you tell the prosecutor about heads and bodies and guns, that will disqualify you for safety valve. And under the terms of the proffer agreement, whatever you say in the proffer can be used to assess your safety valve eligibility. So if you come in trying to get that 5K, you may be booting yourself out of safety valve just because you will tell the prosecutor something different. So don't do that. And just be careful. And if your lawyer is telling you the best thing you can do for your case is to come in and proffer, that may be true, but really read that agreement and understand how they're able to use those statements against you.